Guys, welcome back to the show.
Great to be back.
Okay, so this is a little dense, but I feel strongly and I feel confident that the three of us are going to be able to explain this to the audience in a way that they can get. So Judge Aileen Cannon is trying to decide whether Trump improperly had all these documents and improperly stored the documents and then didn't give the documents back. But the question is, did he have documents he shouldn't have had down at Mar-a-Lago? And Trump has said all along, I'm covered by the Presidential Records Act. And you know who else said that? Mike Davis on our show like 2 summers ago, Mike. You came on, this is when we first met you. And you made the strong case like he can do everything he did. He doesn't have to make special designations. He was entitled to have all these documents and he didn't have to do anything special. And that's an affirmative defense to all of these charges. Well, Trump's lawyers have just proposed Mike's exact argument in their proposed jury instructions before the judge. And rather than saying, as so many on the left did when they heard this argument from Mike and others, that's absurd, that's not what we're going to put in a jury instruction, she did it. So she said to the lawyers, I want you to write me up jury instructions based on the following 2 alternative premises. One is the Mike Davis argument, that Trump was allowed to have it all. He didn't have to make any special designations. And that's kind of an affirmative defense to all these charges against him. And that would be one jury instruction, which would totally get Trump off entirely. And Jack Smith himself concedes that in his papers, saying, basically, what the hell are you doing? What are you saying? If that's the jury instruction, the case is over. So what are we doing here? The other instruction is a little bit better for Jack Smith, but still not good for him. It's still not what he wants. He didn't get any proposed jury instruction requirements that he wanted. The other one is, okay, jury, you can look at whether a record retained by a former president, whether the government has proven beyond a reasonable doubt that that record is either personal or presidential. And the follow-up would be, if it's presidential, he shouldn't have had it. If it's a personal record under the Presidential Records Act, he was allowed to have it. Now, keep in mind, Jack Smith is saying the Presidential Records Act doesn't apply at all here. I don't want to see the Presidential Records Act mentioned in jury instructions to the jury in this case at all. It doesn't belong. And the reason he says it doesn't belong is because he's charging Trump under the espionage statute. And he says, you don't get to say I had highly classified CIA briefings and I was allowed to keep them forever as a personal document under the Presidential Records Act. That the Presidential Records Act is supposed to just say, hey, if you made personal notes while you were in the presidency that you want to take with you when you leave, okay, you can do it. That's what Jack Smith is arguing. Like, why are we even talking about presidential records? That's not a defense to espionage and taking documents that are highly classified. And both of her proposed jury instructions that she wants them to give her like specific language on assume, number one, that the Presidential Records Act does apply in this case. Jack Smith's mad. And in one instance, that therefore the jury has to decide just personal or professional, 50-50. And if they go with personal, Trump wins. And the second one is, as I said at the top, that under the Presidential Records Act, it's ball game. The president can do whatever the hell he wants. He can take whatever the hell he wants. No special designations, the Mike Davis argument. Do I have my facts generally correct? I'll start with you today, Dave. Good to see you.
Great to be back with you, Megyn. And Mike, you've got it right. And that's why Jack Smith was so upset, because the law says that the Espionage Act is the Espionage Act and obstruction is obstruction. And there's nothing in the law that says the PRA, which was a law that was enacted after the Nixon administration, is allowed to override that. You quoted the PRA correctly. And what Judge Cannon came up with were 2 scenarios that were completely erroneous. And that's why Jack Smith had a conniption about it. In fact, I would love to see what he did behind the scenes. If you saw what he did in his pleadings, this is a mild-mannered guy normally. And so he's saying to the judge, you're wrong about this. And if you don't change your interpretation right now, then we're going to go to the 11th Circuit and get you reversed. And then there's the threat of getting her removed from the case. So I do believe that this is a real, an understandable concern for Jack Smith, and he will push that nuclear button if necessary.
So normally you couldn't take such a case up on immediate appeal where she ruled this is the standard of law, or this is what I'm going to do in a jury instruction. But he argues in this, you can, when your proposed jury instruction as a judge, it completely eliminates the prosecution's chances at getting a conviction. He says that.
Right.
Go ahead, Dave.
Right.
I'll let you finish.
Yeah, Megyn, absolutely right. And here's the issue. What Judge Cannon did was not a final order. So you can't really appeal it yet. And so that's why Jack Smith is not appealing what she did. What Judge Cannon said is, I want you parties to engage in the following. So it's not really a direct, specific order. And that's why Jack Smith is saying, hey, be specific. And if you want to dismiss this case, then do it, because then we can appeal you. But if you wait and you adopt this later on, or you dismiss the case during trial, then we're screwed. Then we cannot appeal it because double jeopardy attaches once a jury has been seated. So either dismiss this case now, or make it specific that these are the jury instructions you are going to use. Don't use these weasel words of engage that prevents us from appealing, because we are ready to appeal unless you change your ways.
Mike, kudos to you in driving the main defense, which now has persuaded this judge, at least in part. You've called this, really, I remember this because we were all kind of confused about the Presidential Records Act, and you came out swinging. I didn't know you. I was like, who is this guy? He's brilliant. Listen to this argument. We had you on. You spelled it all out. People mocked you. They're, oh, who's that? Here it is. It is his defense, and this judge has bought it, at least in part, because Presidential Records Act is both in number 1 and number 2, and number 2 is the Mike Davis defense entirely, which has got Jack Smith spitting mad today.
Well, I mean, I people say that I'm crazy, but I tend to be right. And I would say this, that I didn't make up this legal theory. This was a 2012 decision by an Obama judge, Judge Amy Berman Jackson, when President Clinton had 8 years, 79 tapes of audio recordings in his sock drawer. And these audio recordings were recorded by the White House Deputy Chief of Staff for Operations. So they're definitely White House records. And they're recordings of President Clinton's conversations with his national security officials, his foreign leaders, many other highly classified, born classified, the most classified secrets imaginable, the thought process of the president on national security matters. And when Tom Fitton at Judicial Watch sued for these records, that's where we got the Clinton Sartre case in 2012, that this judge said that it is there are presidential records that belong to the government, but the president can access them anytime he wants. He can have his records anytime he wants, even if the government owns them, or they could be personal records. And the mere fact that President Clinton took these highly classified recordings out of the White House with him and did not turn them over to the archives when he left office, deemed them personal under the Presidential Records Act. You may not like that ruling. You may think that ruling is incorrect, but that is the ruling of that 2012 judge, and Judge Cannon is following that precedent.
Just on the question of whether he can appeal her immediately, Dave, he writes the following in his brief. It is vitally important that the court promptly decide whether the unstated legal premise underlying this recent order does, in the court's view, represent a correct formulation of the law. If the court wrongly concludes that it does, and that it intends to include the PRA, Presidential Records Act, in the jury instructions regarding what's authorized under Section 793, which is the Espionage Act, it must inform the parties of that decision well in advance of trial. The government must have the opportunity to consider appellate review well before jeopardy attaches, which is when you swear in the jury. Then he cites 2 cases for the following premises. The adoption of a clearly erroneous jury instruction that entails a high probability of failure of a prosecution, a failure the government could not then seek to remedy by appeal or otherwise, constitutes the kind of extraordinary situation in which we are empowered to issue the writ of mandamus. That was citing to an appellate court, and then a similar finding in another appellate court case from a different jurisdiction. So he's saying, if you're going to stand by this, and these are the 2 proposed jury instructions we're having to choose between, I'm going to mandamus you. I'm taking it up to the 11th Circuit Court of Appeals, and I'm going to have your bosses slap your hand and get this taken care of right away. But the problem, Dave, if he does that, if Aileen does this, and then Jack Smith does the mandamus, it's more delay, which works for Trump.
Agreed. But if you come at it from my perspective, which was this case was never going to go to trial before the election, then I think Jack Smith has no choice. I think knowing that this case was always going to be pushed back, this case has been slow walked from the beginning, that he's got to go to the 11th Circuit, but he can't do it yet. This is the frustration for Jack Smith. It's not just that he sees this as an erroneous interpretation of the law, but it's that he's not able to appeal it yet because Judge Cannon is saying, let's just engage. This is not a final order. These aren't the jury instructions. And number one, you don't do jury instructions this far out. There's not even a trial date set. I've never seen jury instructions being proposed this far out. And number two, if you're going to give jury instructions, do it. Then Jack Smith can appeal it. But if she continues down this road and says, let's discuss it, and then issues her final jury instructions in the middle of trial, which is what normally happens, then Jack Smith is done because he cannot appeal it. It's over. Double jeopardy attaches. And he sees this case slipping away if that happens. That's why he got so hot under the collar.
He's not as bad off if they wind up with the first jury instruction, not the one, the second one that says, as she puts it, I'll paraphrase here, quoting here actually from Andy McCarthy's paraphrase of her proposal on the second. Under the Presidential Records Act, this is the devastating one to Jack Smith's case. Under the PRA, while a presidential term is ongoing, only the president has authority to categorize records as personal or presidential, and neither a court nor a jury may review that decision. Moreover, because the PRA defines no formal means by which a president must make that categorization, it must be inferred from a former president's retention of a record that he had categorized it as personal while president. Andy goes on to say, Dave Ehrenberg agrees, Mike does, I do. I haven't seen any dissent from anybody on this next point. Quote, this would ask jurors, this is Andy, to assume that Trump had complete authority to take the records he wanted from the White House under the PRA. And Andy goes on to say, one must assume that Prosecutor Smith and his staff were dumbfounded upon reading this order. The second scenario is Trump's defense. If Cannon ultimately decides that it is an accurate statement of the law, this case cannot survive. These 32 counts against him in the Florida case cannot survive. So this is true. Like if she's telegraphing where she actually stands on this may be her ruling that this will be the jury instruction, or that she finds as a matter of law. I mean, like that's one of the things I want to get to. But in any event, it's possible the 11th Circuit will not accept mandamus. They might not, or they might take it and affirm her. It's over. The Florida case is done. Correct, Mike?
Yes, and it should have never been brought. Dave said that this case has been slow walked since the start. He's right. The Biden Justice Department waited 30 months to bring this indictment, right? And it is they had the Presidential Records Act listed in their unprecedented search warrant of the Office of Former Presidents when they got that warrant from the biased magistrate judge Bruce Reinhart, who had just recused from Trump's civil case against Hillary Clinton 6 weeks prior because of his Facebook post trashing Trump. Somehow that judicial bias went away, but they had the Presidential Records Act listed in the search warrant, but they don't have it listed in the indictment because Jack Smith knows that the Presidential Records Act kills his case.
The other question I have, which I just made reference to, is why is this even arguably, Dave, being kicked to a jury? If the Presidential Records Act is a defense to the accusation that you committed espionage by having classified CIA documents, or if it isn't, that's for Judge Cannon to decide. Why would she propose a jury instruction asking the jury to decide that?
Exactly, Megyn. There's nothing I can add to what you just said. It makes no sense. Even Donald Trump seems to oppose that. He likes the second jury instruction, which is the equivalent of a get out of jail free card. It's over if that second jury instruction is adopted. If the first one's adopted, Jack Smith has a chance. But why is the jury going to be determining whether the PRA makes certain documents exempt from espionage laws and obstruction and all this stuff? That's not how it works. That's not the law. The jury is not supposed to be doing that. It's a question of law, not a question of fact. And questions of law are decided by the judge, not the jury.
Yeah, how the hell is the jury supposed to know whether the Presidential Records Act is a defense to the Espionage Act? Like, that's so complex. Most lawyers can't even understand that, but certainly not the jury's not going to know. if it seems to me, Mike, like the judge needs to find her spine and say, this is what I find. If this is what she thinks, she should say what you said. The Mike Davis defense. The Presidential Records Act is an affirmative defense to the Espionage Act charges, and therefore I find it applies. And in this case, is going away before we ever get to a jury. I don't get why she's trying to toss this to the jury.
Well, no, the jury instructions are the statements of the law from the judge, and the jury has to follow the jury instructions. They have to follow the law, but they still have to make factual determinations, and there's still an obstruction. There are still obstruction charges with this case. There are still factual determinations that they may have to make. Did President Trump not turn these over to the archives when he left the White House? And if he did not turn them over to the archives, does that mean he deemed them personal? I mean, I don't understand with jury instructions. Those are matters of law, not factual determinations.
But I mean, the instruction seems to eat up all the decisions the jury would have to make on anything not obstruction. Obstruction that's the second piece of the case. So that actually could potentially still stand because he had these documents and he had a subpoena to turn them over and he didn't turn them over. But the crux of the case is that you had these documents that were classified and you shouldn't have had them. And what she's saying in this second jury instruction is, under the PRA, while a term is ongoing, presidential term, only the president has the authority to say whether they're personal or presidential, and neither a court nor a jury may review that. Okay. And then because the PRA defines no formal means by which a president must make the categorization, it must be inferred from a former president's retention of a record that he had categorized it as personal while president. Well, that takes away all the decision. What decisions does the jury have still to make if this is the jury instruction, Dave?
Yeah. Megyn, there were more than 300 documents with classified markings that were recovered from Trump. How in the world could that be considered personal documents? That's not how the PRA works. The PRA doesn't overcome the whole classification process, and it's definitely not for a jury to decide that. And that's why I think we can all agree, whether you agree with the second instruction or not, and that's where Mike and I would differ, but I can't imagine anyone thinking that this is all a jury question as a matter of fact rather than a matter of law.
Go ahead, Mike.
No, it's because she's instructing the jury on the law, and then you look at the willful retention of those documents and the obstruction, right? So they're going to have to make factual determinations on willful retention and obstruction after she instructs them on what the president can and cannot do.
Just to clarify, you're getting to after he got the subpoena, after Trump got the subpoena for the docs.
Yes, that's the whole point of this. Is Jack Smith is charging willful retention under the Espionage Act.
Right. But
so
Megyn,
your position is this second jury instruction is potentially it is alien canon making a ruling that the PRA allows Trump to do whatever he wanted with respect to holding on to the documents. And now jurors, you're only dealing with what happened post subpoena. Because look, I mean, for the audience at home, I got a bunch of documents sitting right here on my desk. I'm allowed to have these. There's absolutely no question. I'm entitled to them. They're my documents. They're personal. They're professional, but they're mine. But if the feds subpoenaed these documents for some reason, I would have to turn them over unless they were attorney-client privilege. I'd have to give them, I might not want to give them up. They're my notes. But once you get a federal subpoena, you have to turn them over. So those are the two pieces of the case. And so what you're saying, Mike, is this is telegraphing. Yes, I will remove all of the counts from the jury about whether he wrongfully had the documents to begin with and craft me an instruction that speaks only to, did he comply with the subpoena?
Yeah, well, there's willful retention under the Espionage Act and there's obstruction. But yeah, you're going to have a bigger problem with this, be separate from the personal records versus presidential records. The personal records that belong to the president, the presidential records that belong to the government. Under the Presidential Records Act, he is allowed to access, he's allowed to have his presidential records anytime he wants. That includes any document created or received by the president or his White House staff. And so if the CIA drafts an intel assessment and gives it to the president, that is a presidential record, right? And so he's allowed to have his presidential records, whether he deems them personal that belong to him or presidential records that belong to the government that he can access anytime he wants. Remember, before the Presidential Records Act, presidents were allowed to keep all of their presidential records were personal records that belonged to the president personally. Nixon was trying to hawk his presidential records, and that's why they passed the Presidential Records Act, but there is no criminal component to the Presidential Records Act. There's a separate Federal Records Act that deals with all the other government records besides presidential records, but the Presidential Records Act is controlling here, and it's not espionage for a former president to have his presidential records. It's allowed by the Presidential Records Act, and I've been saying this for nearly 2 years.
Mm-hmm. You have. When I interviewed Trump in September, we got into this exact thing. It was as if you two and I had sat down and had a strategy session about what to ask Trump before the interview, because you'll see I'm asking him these very questions, and how he answered them was interesting. And I will say, even in the moment and thereafter, has been a reminder to me that Trump is smart. He is a clever guy, and he saw me coming, from a mile away, and he knew right when to get out of bounds or when to stay in the ring. He's clever, because his freedom is on the line, and he must be, but he's clearly been paying attention. Watch what happened.
The obstruction case says, so even if you had the right to the documents, once you get the subpoena, you got to fork them over. The subpoena said, give us anything with a classified marking. Go ahead.
This is just like the Mueller stuff. They create a fake crime, and then they say you obstructed. I have been complied with everything. They took documents that they weren't even allowed to do, but they took documents, they took everything.
They found documents
and I would have given it to them. All I know is I'm allowed to have those documents.
But once you get a subpoena, you have to turn them over.
I know this. I don't even know that, because I have the right to have those documents. So I don't really know that. I don't think there's any dispute that I'm covered under the Presidential Records Act.
Well, you're covered, but it's not clear that it allowed you to take all those documents. You can't say
it says what it says. You're allowed. And
do you believe that every CIA document that came to you as president was automatically yours to keep, no matter what?
I'm not going to answer that question,
so
because
that's the dispute.
No, I did absolutely nothing wrong, and I wouldn't even be talking to you if I thought I did.
So it's pretty telling, right? Where he's like, I'm not going to answer that one, because that question got right down to the heart of what we're arguing. Does CIA highly classified briefings to the president in a document become the president's property to do with what he wants just because he has it, right? That's kind of what I'm asking there. And he knows enough to know that's too controversial for me to just say yes to, even though it appears to be what he did. He's arguing the Mike Davis argument, which is, yes, that is what I believe, but he didn't want to quite go that far. Go ahead, Dave.
Megyn, it is telling, though, that Trump never raised this as a defense until much later. This is indeed the Mike Davis defense. Not until Mike Davis brought this up was this adopted as a defense, because Jack Smith cites in his pleadings, he said that we have spoken to all these witnesses at the White House. No one ever heard Donald Trump consider these documents presidential records or personal records. He's never spoken about it. It was never even brought up until later. And that's apparently the time when Mike Davis, smart lawyer as he is, brought it up, and then they adopted it. So to be presidential records, you have to believe that they are personal records. But in any event, it doesn't matter, because classified documents are classified documents. And even if you believe you own them, you don't, any more than you own Air Force One.
Well, this is what Judge Cannon needs to decide. Meantime, and we'll watch it. Obviously, this has huge implications for how this case is going to go forward, when it's going to go forward, if it's going to go forward. Meantime, there's been shock and horror in the press over what Judge Cannon is doing. As you point out, she hasn't actually made the ruling of what the jury instruction will be yet, but she's clearly entertaining two possibilities only, and neither is particularly great for Jack Smith. So here's just a sampling of what we've heard in response. Satu.
I'm concerned about her handling this case. I'm not sure that she has the legal acumen. I don't have confidence in her abilities to be fair or to be seen as fair.
I don't think her conduct is baffling. I think it's intentional. So she is consistently making erroneous legal decisions. They are consistently always on the side of Donald Trump.
If she makes these wacko rulings like she made last time,
she's got at least a
pinky finger on the scales of justice for Donald Trump.
So to correct myself, that was a stop montage of criticism of Judge Cannon even prior to now. But I could have put one together in response to this ruling too. They're upset and they're on Jack Smith's side. They share his outrage. This is unfair and so on and so forth. But out of the other side of their mouths, Mike, they're very, very upset at Donald Trump being critical of the judges. They could say whatever they want. Michael Cohen can say whatever he wants about Donald Trump. So can Stormy Daniels. And the pundits can say whatever they want about this judge. The one thing that cannot happen is that the defendant in these 4 cases be critical of the judges because somehow they're transforming that into, quote, threats, that the judges are being threatened and that he therefore has to be gagged. We have seen him gagged in the New York criminal case, though not when it comes to criticizing the judge himself and not when it comes to criticizing DA Alvin Bragg. But what we've heard is this sanctimonious, parade of witnesses on the left saying how wrong it is to, quote, attack a judge, while I just played you right there some of the criticisms Judge Cannon has received. And by the way, she too has had death threats from anti-Trump lunatics who promised to kill her, one of whom has already been sent to jail. It does happen, but these same people who were so outraged that Trump had some criticism of Judge Merchan in New York had no problem with Eric Holder or any of these other people and their criticisms of Judge Cannon. What do you make of it?
Well, I would say this: if there's anyone on the planet who must have the constitutional right to speak out about the judge, about his staff, about the prosecutor, about the witnesses, about the potential conflict of interest of the judge with his adult children, with the process, it is a criminal defendant going through a criminal process. He has the absolute First Amendment right to speak out about those issues. He has the Sixth Amendment right to a fair, public, and speedy trial. He has the right to confront witnesses. And to label as a violent threat when a criminal defendant brings forward evidence of potential bias by the judge is the most dangerous thing I can imagine in our judicial system. That criminal defendants are punished. They're unconstitutionally, illegally gagged, and illegal prior restraint on free speech. It hobbles their ability to have a fair trial, to have due process. And take Trump out of the picture. If they were doing this to any other criminal defendants, these same people would be outraged. But because this is Donald Trump, they have a different set of rules. They have Trump derangement syndrome. Remember, these same people who are going crazy because President Trump correctly raised evidence that Judge Merchan, who donated to President Biden in 2020 a small amount, and donated to another anti-Trump group in 2020 a small amount, his adult daughter, according to the New York Post, is making a lot of money fundraising for Democrats, including fundraising for this trial over which her father is presiding, the one that starts in about 1 week, a week from Monday. And so, of course, President Trump is going to raise this issue of bias. And when he does that, it should not be labeled a violent threat. And for a federal judge to go on CNN, Reggie Walton from DC, to do this, that is outrageous. That violates the judicial canons.
Let me show the audience what you're talking about. This is where I was going. This is the federal judge who tried the Scooter Libby trial back in the day, Dick Cheney's right-hand man's chief of staff, for alleged leaking. And he oversaw this case. Reggie Walton, U.S. District Court judge in the District of D.C. And he did an extraordinary and I believe inappropriate thing. He went on CNN and he gave an interview to Caitlin Collins and he started ripping on Trump. He was reacting to Trump's criticism of Judge Merchan in the New York criminal case about the Stormy Daniels hush money payment. I'm sure he's got a lot of thoughts on it. The judge should have kept quiet. He should have shared them with his wife, not with Caitlin Collins, because now he's in a lot of trouble because Mike Davis saw the segment, and we'll get to what happened. But listen to what he said.
It's very disconcerting to have someone making comments about a judge, and it's particularly problematic when those comments are in the form of a threat, especially if they're directed at one's family.
But do you think that's something that Donald Trump considers when he posts something like this?
I can't get into someone's mind to say whether they appreciate the impact that they're doing, but I would think that any reasonable thinking person would appreciate that when they say things, it can sometimes resonate with others. I think it's very important that people in positions of authority be very circumspect in reference to the things that they say.
I keep looking for Trump's threat against Judge Merchan and his daughter, and I don't see it. I see criticism, strong criticism. He calls the daughter and the Merchan family Trump haters, pointed out her job, Loren, the daughter, in an April 2023 post, as you just did. Says she's a rabid Trump hater who's admitted to having conversations with her father about me, and yet he gagged me. She works for crooked Joe Biden, Harris, Adam Shifty Schiff, and other radical leftists who campaign on getting Trump and fundraise off of the Biden indictments, including this witch hunt, which her father presides over, a total conflict. Again, just the other day, Judge Juan Merchan, who's suffering from an acute case of Trump derangement syndrome, whose daughter represents crooked Joe, Kamala, Shifty Schiff, has just posted a picture of me behind bars. We talked about the correction on that, her obvious goal, and makes it completely impossible for me to get a fair trial, has now issued another illegal, un-American, unconstitutional order as he continues to try to take away my rights. There's no threat. There is no threat. And by the way, you can be arrested for threatening a judge. He wasn't, and there's a reason he wasn't. So before we get to what Mike did in response to Judge Walton, Dave, do you agree that there's no threat, that Trump, while he's been incendiary about Judge Merchan and, been critical of the daughter, he has not threatened them?
Yeah, I think it's incendiary. And as far as him personally threatening them, no, I don't think it rose that far. But I do have some concerns that when Trump goes on social media and he says stuff like that, we've seen it before, that his rabid supporters will go ahead and make death threats and attack. And that's the problem. You really do harm the trial when the judge now has to look over his shoulder every time, and the witnesses feel threatened because of Trump supporters. Trump knows what he's doing with his words. I mean, we've seen it before. Cesar Sayak, the nut down here in South Florida, who sent bombs to members of Congress who opposed Trump. So we saw the guy who showed up outside Obama's house because Trump doxed Obama in Georgetown. We've seen it. So that's the concern. And that's why one thing to know is that defendants don't have the same First Amendment rights as the rest of us. It's one thing for a legal commentator on TV like Andrew Weissman to say it, but when a defendant says it, it can run afoul of the rules and the law, because defendants, when they go to first appearance, are told you can't contact witnesses, you can't contact the victim, you can't even drink alcohol or do drugs in some cases that we have. So they don't have the same rights as we all do. So my concern is not necessarily that his words are a direct threat to the judge, it's that it's going to be interpreted by his supporters to go ahead and go after the judge's family and the witness's family, and it amounts to intimidation.
Mike, your thoughts?
That is an interesting take by Dave, and I like Dave, so I won't criticize him. I would say this, that if anyone must have the ability to speak out against the judge and his potential bias, it is a criminal defendant. And we don't have heckler's vetoes where, because someone may misconstrue that the defendant's outraged by this evidence of bias, that some deranged lunatic may threaten the judge. That's not how it works. I don't remember this Judge Reggie Walton raising any concern, especially not moonlighting on CNN, when the Biden White House press secretary and the Biden Justice Department encouraged illegal obstruction of justice campaigns for months outside of the homes of conservative Supreme Court justices and their families. Even after they went to safe houses, even after the 1 a.m. assassination attempt against Justice Kavanaugh, his wife, Ashley, their two teenage daughters. I don't remember Judge Reggie Walton going on CNN after Judge Eileen Cannon got death threats, including people convicted, as you said, Megyn. This is selective outrage by Judge Reggie Walton, and it shows that he could be political here, and maybe that's why the judicial canons tell judges to keep on their judicial robes and not crawl into the political arena, especially not moonlight on CNN during a criminal trial.
Right on. Very powerful argument. And that's why you did what? Tell us what you did.
Well, the Article 3 Project, the right wing, as we're called, the group that I run, filed a judicial misconduct complaint against Judge Reggie Walton for violating Canon 3A6, which says this, quote, a judge should not make comments on the merits of a matter pending or impending in any court. And Judge Walton clearly did that. And it's not an accident. This was a pre-planned interview, and he had to have known that this would taint 4 different jury pools. Trump is facing a criminal trial in New York in about 1 week. He's facing a criminal trial in D.C. He's facing a criminal trial in Georgia and in Atlanta. He's facing a criminal trial down by Dave in the Southern District of Florida. These judges need to learn to keep their mouths shut, and it violates the judicial canons when they don't. And this is part of a pattern by these D.C. federal judges. Beryl Howell did this, gave a speech. Congresswoman Elise Stefanik filed a judicial misconduct complaint against her. What these federal judges need to understand is they need to keep on their judicial robes. They need to stay out of the political arena. They definitely need to stay off CNN. And if they don't clean up their own house, I guarantee you that Congress will do it for them.
Yeah. Talk to your wife. Write it in your diary. You don't have to go talk to Caitlin Collins. That's the thing about this judge, Dave, in sentencing some of the J6 defendants who have come before him. He has said he's unsure how people live with themselves when they call January 6th defendants political prisoners. He's criticized people who are following, quote, the calls of a demagogue. He said, I think our democracy's in trouble because unfortunately we have charlatans like our former president who doesn't, in my view, really care about democracy, but only about power. He's tearing the country apart, or as a result of that, it's tearing the country apart. This judge is obviously a Trump hater. He's not, to be clear again for the audience, trying any current Trump cases. He's the one who decided to, as Mike points out, moonlight on CNN as a CNN commentator to come out to say how terrible it is for Trump to allegedly threaten judges, meaning Judge Merchan, which he hasn't done. He's wrong on every front here, Dave, and you tell me whether something should happen to him.
Yeah, I understand why Mike Davis issued the complaint. I was surprised when the federal judge went on national TV and said, I think a lot of us, understandably, were surprised. But kudos to Mike Davis. He not only is a legal analyst with you, Megyn, he's also a newsmaker. Here he is I see it all over the place. He's Trump ally. He's called a Kavanaugh ally, a right-wing jurist. I don't know what to call him, but you've been very busy, Mike. And as far as his complaint, I looked up the canon he cited, and it's Canon 3A6 of the Code of Conduct for judges. And here's the part that matters. It says this: a judge should not make public comment on the merits of a matter pending or impending in any court. And I don't think he spoke on the substance of the trial, but he did speak, I think, on the substance of the gag order in that sense. So in that narrow sense, could he get in trouble for speaking out about a matter before the court? That's the gag order, perhaps. And that's where he may have some issues. But I don't think his words got to the substance of the case. And so it's not as cut and dry. But I will admit that it did seem, let's just say, unusual to see a federal judge on Caitlin Collins' show.
I know. He just couldn't control himself. He couldn't help himself. And by the way, not for nothing, but I know some federal judges, and they've definitely got thoughts that they will share with you privately, but they would never come on my show to tell you exactly what they think about the Trump trials or whatever. It's they understand, there's a very high bar of behavior required of DAs like Dave and Fannie, and of judges, higher even than regular lawyers, and most of them live up to that. Stand by, quick break, back with you guys. There's more to go before you guys go. Stay with us. Let me tell you a story about a guy named Leo Grillo. Leo was on a road trip and came across a Doberman. The dog was severely underweight and clearly in trouble. Leo rescued this dog and named him Delta. But sadly, Delta was just one of many animals that needed help, and that's inspired Leo to start Delta Rescue, the largest no-kill, care-for-life animal sanctuary in the world. They've rescued thousands of dogs, cats, and horses from the wilderness, and they provide their animals with shelter, love, safety, a home. April marks 45 years since Leo rescued Delta. Delta Rescue relies solely on contributions to stay open. And if you would like caring for these animals to be part of your legacy, speak with your estate planner because there are tax benefits to this. You can grow your estate while letting your love for animals live well into the future. Check out the estate planning tab on their website to learn more and speak with your advisor. We call dog man's best friend for a reason. You can help those who need it most. Visit deltarescue.org today to learn more. No kill shelter. That's so important. deltarescue.org.
He could be looking at jail. If you have someone who's contrite, if you have someone who shares that he's respectful of the rule of law, that this was an aberration, that is something that the court can take into account. But if you think that the defendant actually is running basically as an outlaw, and is basically thumbing his nose at the judicial process, and it shows no sign of remorse and essentially is a recidivist, those are factors that a judge can consider.
That's former federal prosecutor Andrew Weissman. Welcome back to the Megyn Kelly Show. Mike Davis, Dave Ehrenberg remain with me, suggesting that Trump could be looking at jail time in the Judge Merchan case, in that Stormy Daniels hush money case. Jail time because he's a recidivist, Mike? What?
Andrew Weissman is such a partisan blowhard. It's just comical to watch him on. He just he's put down his glass of wine and does MSNBC hits on a regular basis every night. It's just hilarious. Remember what they're alleging in New York. You have this Soros-funded Manhattan DA bringing this unprecedented indictment against President Trump under the theory that these time-barred, at best, misdemeanor bookkeeping charges for President Trump paying off a nuisance claim somehow got transformed into 34 felony campaign finance violations. The prior Manhattan DA, Cy Vance, the Manhattan U.S. Attorney, the Federal Election Commission, and Alvin Bragg himself declined to prosecute this bogus legal theory. It wasn't until Matthew Colangelo got sent from the Biden Justice Department, a senior political operative, to bring the first indictment ever against a former president and a likely future president. And if Democrats think they're going to put President Trump in prison over this, I welcome it, because that will guarantee that President Trump wins by 5 points on November 5th, 2024.
My God,
because
Dave,
this is the dumbest case.
You're somebody who actually does put people in jail. Legitimately, is there any possibility Trump goes to jail if convicted in the Stormy Daniels hush money case?
Megyn, it's possible. I don't think it's likely, but I do think it's possible. I would disagree with Andrew Weissman.
Would do a 90-10. What is it?
I think 25% chance he gets a jail sentence, a prison sentence.
That high?
Yeah, because I do think the one thing Andrew Weissman, I think, said that I agree with is that he could, based on his behavior, the judge can take all that into account, his lack of remorse and the fact that he's been doing it for years. I wouldn't call him a recidivist, though, because when we use recidivism here at the local level, it's more like a career criminal with a long rap sheet. Yeah, and even though he's been charged in 3 other cases, he's never been convicted of anything in the past. I would say this: I've met Andrew Weissman back at MSNBC. Mike, that's a network that you don't get in your home. But I met Andrew backstage. He's actually a nice guy, and he's on all the time. So yeah, I disagree with him on calling him a recidivist, but I do think there's a 25% chance he gets prison time. And
oh wow, okay,
I don't know.
Wait, let me move on because I have a couple other things I want to hit. This is very important to get to.
I don't think he'll serve it.
Okay, yeah, this is very important to get to. As you guys know, Trump was gagged in that case by Judge Merchan. Again, as I said, not about criticizing the judge or the DA, but pretty much everybody else, including the judge's daughter and the court staff and the ADA, all that. And you know who thinks that's really unfair? I know you were wondering what this guy's take would be. Michael Avenatti, who's currently in prison himself for defrauding all of his clients, a bunch of clients, including Stormy Daniels, sentenced to 14 years in 2022 after being convicted of cheating numerous former clients out of millions of dollars in other financial crimes, not due to be released until 2035. And he tweeted out, "We can't be hypocrites when it comes to the First Amendment. It's outrageous that Cohen and Daniels can do countless TV interviews, post on social, and make money on bogus documentaries, all by talking shit about Trump. But he's gagged and threatened with jail if he responds? What on earth is happening, Dave? He was Trump's chief antagonist, not to mention Kavanaugh's and all these. Now I guess he sees the light now that he's in prison.
How is he even allowed to tweet from prison? What kind of prison do we run in? Right?
Correct.
Yeah, no, that's number one. And number two, boy, he really wants a pardon, huh? He is, as we say in the wrestling business, he turned heel to get a pardon, but he's very transactional. This guy would, he's all transactions we've known from his previous convictions. And so I think he's just angling for a pardon because he knows he's not going to get one from Biden.
It's amazing. Last but not least, Mike, there are some on the left, like Mehdi Hasan, but not just him, calling for Justice Sotomayor to step down and retire right now so that if her type 1 diabetes acts up over the possibility of a Trump administration or even a Biden administration with a Republican Senate, the Dems get the seat. This is getting more and more buzz. What do you make of it?
This is great. These are like blasts from the past for me. Michael Avenatti popping onto the scene. I'm glad they have Twitter in the prison library. When I'm Trump's viceroy of DC, I'll make sure that he gets special Twitter access because of what he's done here. And with Mehdi Hasan, he came after me a couple months ago, and he's back. I'm surprised. Does he even? Did he say this on Twitter? I thought he got canceled from MSNBC. This is just wild.
He did. He writes a column. He said it in a column, but he's not the only one. This is a din that's growing louder amongst Dems who are terrified, given the polls, Trump's going to win. And frankly, that Sotomayor, it's them, it's not me, people, might die, and that Trump will have another Supreme Court appointment and that they can't withstand a 7-2 high court.
Well, I would say this. I mean, if they're worried that we're not going to have a Hispanic woman for the Supreme Court, I mean, isn't Judge Cannon? She's a Hispanic woman. I think she'd make an excellent replacement for Justice Sotomayor on the Supreme Court.
I'll give you the last 20 seconds, Dave.
You can see why Democrats are calling for Sotomayor to step down. They still have PTSD over the whole Ruth Bader Ginsburg thing, and that's what's going on right now.
I don't think she's going anywhere. Not at age 70. Don't bet on it. Okay, you guys are the best. Thank you so much for being here. Mike, Dave, to be continued. And don't go away. We've got much more.